Welcome everyone to Nobel. I'm going to read to you this really great quick book if I can read the entire thing. If not, I'll put it in the description in below this video. Welcome to everyone. Welcome to all the new subscribers. Welcome to all the new subscribers and members over on Boon TV. I'll put the link to that channel in the description below. Tricks and traps used by attorneys, judges, and other species of rats concerning evidence by Valiant Liberty. The rats have laid a minefield of tricks and traps for the unwary, uninitiated, and ignored pro se litigant who dares trespass into the monopolized realm of Texas courts. By skillful and manipulative use of the rules of court and judicial interpretations of the rules, the lawyers, with the complicity of the judges, are able to get their hearsay evidence entered into the record as facts and deprive the ignorant pro se of his evidence. When the other side can get whatever they want, including hearsay, admitted into the record as evidence, and the pro se cannot get anything into evidence, the outcome is going to be obvious. You can't win without evidence to prove your case. This does not seem to be fair or in the interest of justice. But fairness and justice have nothing to do with the operation of Texas courts. The pro se litigant is expected and required to follow the rules. The pro se gets no slack in Texas courts. A party acting pro se must comply with substantive law and procedural rules. In Re. Caldwell, 1995, 918, capital S as in Sam, W as in water, 2, D as in dog, 9, 10, period. If one is ignored of the rules and of how the rats manipulate the rules, the rats will invariably strip you of your property, steal your children, throw you in prison, or all of the above. And the rats will have done nothing wrong in the eyes of the courts. You should have hired an attorney, they will say. However, the final outcome might well be the same if you had. Even if a litigant wins the aid of an attorney, often the only difference in the final outcome is that the attorney, not the adverse party, ends up with all your money and property. In either instance, you will have been impoverished and reduced to a pauper by the Texas form of justice. You can win, but still be the loser. The following information and authority is found scattered through it, though is taken from O'Connor's Texas Rules Civil Trials 2001, published by Jones McClure Publishing Incorporated, expecting the comments in brackets. This is the best rule book concerning Texas rules of court that the author has seen. It is filled with annotations and explanations of the rules and procedures for Texas courts that can be found in no other one place. If you want to play in Texas courts, you should have a copy. It may be ordered by calling 1-800-626-667. They also publish a book containing forms for pleadings. It is imperative that the pleadings be properly drafted, or else you will surely lose. This essay is in no way intended as legal advice. If you want legal advice, hire an attorney if you know of a competent one that you can trust and afford. Otherwise, do your homework. I want to interject here and just put in the Clearfield Doctrine. You guys know I talk about that all the time. The Clearfield Doctrine the United States Supreme Court case, the Clearfield Trust Company versus the United States. And I always talk about Trinzi versus Pagliaro. Go and look those up. I will go through a couple of those in the next upcoming videos, and also know that there's something called violations of the Constitution. You have constitutional rights, you guys. All right, how attorneys' unsworn statements become facts of evidence. How to prevent it. I'm just going to scroll through some of this stuff here and see the titles. How the court prevents you from admitting your evidence and what to do about it. It goes on to say, oh, it's short. It's only 4 pages long. All right, let's go back. How attorneys' unsworn statements become facts evidence or of evidence, and how to prevent it. And you know, I was thinking about Trinzi versus Pagliaro. Statements in brief or in summary judgment is not sufficient for, let me see if I can find them. I'm going to read the whole thing to you. Oh, you guys, here it is. Secrets of the Legal Industry, Part 2 of 3. Argument authorities. Statements of counsel and their briefs or their arguments are not sufficient for purposes of granting a motion to dismiss or for summary judgment. Trinzi versus Pagliaro. You guys, that's an amazing case. Talks about jurisdiction. Do not bear false witness. The judges or the agents doing business, judges and their attorneys, must be present. Same with the agents doing business, police must be present when the act occurs. Keep that in mind. The trial court has the discretion to admit or exclude evidence. The appellate court will reverse only on the abuse of discretion standard. See National Liabilities and Fire Insurance Company versus Allen, 2015. Sam Water 3 Dog 525 527 28 and C City versus Brownsville versus Alvarado 1995 897 Sam Water 3 Dog 750 753. If the trial court sustains objection, it will not admit the evidence. The party who offered the evidence still has other options that it must exercise, or it waives the error. If the trial court overrules the objection, it will admit the evidence. The party whose objection was overruled still has other options that it must exercise, or it waives the error. Remember, you guys, there is no statute of limitations on fraud. Okay, an attorney's unsworn statements are not evidence. U.S. Government versus Marks, 1997, 946 SW 2D 326. However, on appeal, a lawyer's unsworn statement can be considered evidence unless the other side objected at the trial. Banda versus Garcia, 1997, 955 SW 2D 270, 272. Normally, an attorney's unsworn statements must be under oath to be considered as evidence. Banda supra. If a lawyer is presenting facts to the court, the other party should object and ask the lawyer to be sworn and subjected to cross-examination. Banda supra. When in doubt, a lawyer should always object to the statements or another lawyer if the other party is aware that the lawyer is testifying and does not object. The administration of the oath is waived. Fullen-Wider versus American Guar and Liability Insurance Company, 1991, 821 SW2D 658 662. We also have our new book, you guys, with all the laws that we've used in certain cases to win. All right, and you guys keep in mind the straw man, the nom de guerre the nom de guerre strawman account, right? And all of what's going on in these buildings. Doing business as courts, the in ligas jurisdiction is key, right? Are they going after the living flesh and blood sentient being, or are they looking for the straw man? Note that the Texas disciplinary, and also we've just discovered that a lot of these claims, court cases, are actually being done under military operations with the name spelled very uniquely. The last name first, which is, say it's John Doe Smith, so it'd be Smith, right? It's a capital, I think it's a small s and then a capital M, and then IATH is small, comma, and then capital first name, middle name. So it's the last name, comma, first name, middle name. Military operations, you guys, which is what? Fraud. It vitiates fraud, which it vitiates, voided from the very inception, void from the beginning. All right, when the trial counsel foresees the possibility that he or she will testify on behalf of a party about a disputed fact, not attorney's fees, a lawyer should resolve doubts in favor of preserving the integrity of the evidence and decide against continued participation as trial counsel. See Worrell versus Norrell, 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 1989, and then you have the assumed name. That's a whole different topic, you guys. 791 SW 2D 515, 523 N10. A testifying lawyer may still engage in out-of-court matters relating to the case, including preparing and signing pleadings, planning strategy, and negotiating settlement. Anderson, PROD, Prodigy, Incorporated versus Koch, KOCH Oil Company, 1996-929 SW 2D 416-422. So when a lawyer starts testifying to hearsay facts, the pro se should be objecting and demanding he take the stand under oath, submit to cross-examination, and that he withdraw as trial counsel. A party should attempt to secure an explicit ruling admitting or excluding evidence that is a ruling on the record, either in open court or in writing, that specifically state the court's ruling. Example, that the objection is overruled or sustained. If the court does not make an explicit ruling but admits evidence over a specific objection, the court implicitly overruled the objection and the error is preserved. Wolf versus Wolf, 1996, 918 SW 2D 533 542 under Trap 33.1 A2A in parentheses. Error is preserved by an implicit ruling. If the court does not rule, or if no ruling appears in the record, the error is waived. To preserve error, an objection must actually be overruled. If the trial court says that it will rule on the objection later, the statement is not a ruling and does not preserve error. Tia versus Moore, 1955, 284, SWD 2D 175-178. If the trial court invites the party to re-urge the objection later, that is not a ruling. Bushell versus D, 1991, 803 SW 2D 711 S12 712. If the trial court responds to an objection by saying, okay, that is not a ruling. Walmart versus Gonzalez, 1997, 954 SW 2D 777 777 782. Comment, these types of rulings are called equivocal rulings, and any ruling or an objection to evidence that is not overruled or sustained is an equivocal ruling and does not preserve error. There are 1,000 ways a judge can equivocate, and the pro se must be alert to these equivocations at all times, and insist that the judge make a ruling. I am not here to make a plea. I'm here to settle and discharge this matter. For instance, it might be stated, let the record reflect that an object to the hearsay testimony or lawyer shyster has been made, that the court has neglected or refused to rule or on the objection, and I have objected to the court's neglect or refusal to rule. If the court equivocates or refuses to rule, the party must object to the court's refusal to rule and must make sure its request for a ruling and the refusal to rule appear in the reporter's records or in a bill or expectations. For Moores, remember, when you are having a case, you have to write to the agent doing business as judge in private chambers and must state, I come in good faith, here and for the record, making a special appearance as a living flesh and blood, sentient being, in our case, Surrey heirs, heir to the world's vast estate, as an American Indian, a lowly title, Moorish American national. Keep that in mind. See Goodall. If you're not American Indian, don't write that. If you're not Moor, do not write that. See Goodchild versus Baum. If the court equivocates or refuses to rule, the party must object to the court's refusal rule and must make sure its request for a ruling and the refusal to rule appear in the reporter's record or in a bill or exceptions. Remember, Moores, changing your name, right? Keep your birth name that's on the birth certificate. As the powers that be reported to us here that the cabal kept impeccable records, and they know down to the penny what is owed to you. However, it is kept in your birth name on the birth certificate. All right, see Goodchild versus Bombardier, little dash, Brotex, GmbH, Motor Ren Fabric, 1998-979, SW2D1, 6 little dash to 7, and C. O'Donnell versus Roger Bullivant, Incorporated, 1997, 940, SW2D 411, 416, and C. Trap 33.1, A to B in parentheses, in making the preliminary decision concerning the admissibility of evidence. The trial court is not bound by the Texas rules of evidence except those that relate to privileges. Trey Rule 104A, to challenge successfully the denial of an improper exclusion of evidence, the appellant must bring forth the court reporter's entire record. SHV National Conveyance Stores, 1996, 936, SW2D 406, 407. The trial court is allowed a wide field of discretion concerning the admissibility of evidence, and it would seem that the judge can arbitrarily allow or disallow whatever evidence suits his whims. Thus, an attorney with no witness and no facts can stand in front of a judge, state hearsay facts, and strip the unwary and ignorant naked. The license to practice law. They have no license to practice law. The license to practice law, if such a thing exists, truly is a license to steal. They have a union membership card to the Bar Association, the British Accreditation Registry. Don't take my word for it, you guys. Go look it up. The pro se cannot get away with stating hearsay or testifying without being under oath because he is not a member of the gilded monopoly and is not subject to disciplinary rule of professional conduct 3.03 supra, the judge, in his discretion, will politely listen to the pro se hearsay and ignore it, instruct the jury to disregard, and threaten contempt if he doesn't shut up. How the court prevents you from admitting your evidence and what to do about it. Yeah, you guys, the stuff I'm sharing with you, write to us first for all the laws at themullings@gmail.com before you go in there running your mouth, right? If the adverse attorney objects to a witness, document, or other evidence, and the court sustains the objection, the pro se will have no evidence, and the pro se will lose if he doesn't know how to preserve the evidence for appeal. Remember, as stated above, the judge has broad discretion to admit or disallow evidence, and the judge and adverse lawyer are members of the same exclusive monopoly, and they don't want non-members participating in it. If they can, the rats will vigorously punish any non-member for trespassing into their exclusive domain. A party should preserve excluded evidence in an offer of proof before a party is entitled to make an offer of proof. It must offer the evidence at trial. When an objection is lodged, the party offering the evidence should specify the purpose for which the evidence is offered in the reason it is admissible. Before a party is entitled to make an offer of proof, the court must make a ruling that the evidence is inadmissible. Once the court rules that the evidence is inadmissible, the party must make an offer of proof. The offer must show the substance of the evidence that was offered and excluded citations omitted. Keep in mind that all these agents bringing so-called court claims must get permission, a certificate of authority, delegation of authority order from a higher entity, whether it's federal court or what have you, HUD or other higher authorities, before they bring a claim. Also, are you immune, as you might be listed as a corporation under the 14th Amendment? Write to us, you guys, at themullings@gmail.com for more. To preserve oral testimony by a witness, a party offering it must make an offer of proof in the presence of the judge, the court reporter, and the opposing counsel, but outside the presence of the jury. The offer of proof is conducted out of the hearing of the jury to prevent the jury from hearing inadmissible evidence. When making an offer of proof, the lawyer or a pro se may make a concise statement of what testimony would be elicited from the witness. The trial court may add a comment to the offer to show the character of the evidence, the form in which it was offered, the objection, and the ruling citations omitted. Also, you guys, you have to put into the Federal Trade Commission that I am alive letter, and they're saying if you create a trust and you put your properties and stuff in that, you should have that trust registered at the county, just to keep those things in mind. And also, you should put your birth posted in the newspaper for you and your offspring, right? To preserve documentary evidence, the party should, at the time the document is rejected, say, I make an offer of proof of this document and ask that it be filed with the record. An offer of proof to preserve the excluded document may be made in the presence of the jury, because the jury is not prejudiced by evidence in the excluded document that it cannot see. The court reporter should mark the document as an offer of proof and identify it with exhibit number. The document will be filed with the court clerk so that it will be included with the exhibits in the reporter's records. Citations omitted. even when a document is already on file with the court. For example, dispositions and interrogatories. If the court refuses to permit it to be introduced into evidence, the party should submit it as an offer of proof and get the court to rule on the offer. Citation omitted. This surely includes those affidavits that many patriot pro se staple into motions and other pleadings in the mistaken belief that just by virtue of being filed into the record, such affidavits are evidence. It should be remembered that affidavits, like all other evidence, must be testified to under oath by a competent witness in order to become admissible evidence, unless, of course, the adverse attorney runs his mouth about one of his affidavits and there is no objection. To preserve tape-recorded evidence ruled inadmissible by the trial court, the party should, at the time the tape is rejected, say, "I make an offer of proof of this tape and ask that it be filed with the record." As part, you see, when I'm writing, I write this initially. I come to you in good faith. Now I write, even though I've been subjected to bad faith by agents, here and for the record. As part of the offer, the party must describe the excluded evidence of the tape and specify the purpose of the evidence. Now, Moors, keep in mind, just keep this in mind. We created the Constitution for entities that are here doing commerce, occupying our lands, to honor the Constitution as they took an oath to uphold the Constitution as it's a contract. It's a contract. It's a contract for them to follow, honor, uphold in order to do business on our lands. Right? And those of us heirs, Moors, who created that contract, the question is, do we follow and have to follow the said Constitution contract that we created in our house, on our land? Think about that, people. If a transcript of the tape is available, the party should file it as part of the offer. If not, the party should ask permission to file a transcript as part of the offer of proof as soon as it is made. Error is preserved by the court's explicit rule that the evidence in offer of proof is not admissible during trial. However, under Trap 33, error can be preserved if the trial court implicitly overrules the offer or refuses the court to rule on the offer and the complaining party objects to the refusal. Citations omitted. Another way to preserve excluded evidence is with a bill of exceptions. This is an antiquated procedure preserved in Texas law that is so strict and difficult as to be impracticable, but possible in some cases where the evidence was not timely preserved. A bill of exceptions may be the only remedy. It will not be discussed here, but the reader should be aware of the existence of this remedy. The federal rules have no equivalent procedure when excluded evidence is properly preserved. The judge can and may reverse himself if the evidence is relevant and substantive. The probability of a reversal by the court is relatively high because the judge knows he will be reversed on appeal, and judges don't like their decision reversed on appeal. In fact, judges don't like their decisions appealed, even if they are upheld. Whoever has the preponderance of the evidence in civil case will win. How can you win? If you have been prevented from getting your evidence into the court. How can you win? Joe Shyster gets his hearsay testimony into the record without the risk of cross-examination. Evidence is everything. If the record does not contain your evidence, you have nothing and will lose. On the other hand, if the pro se can keep the adverse attorney's bullshit hearsay out of the record, he just might deprive the adversary of evidence and win. Send and receive Hotmail on your mobile device. Click here. Alright, you guys, so here you go. I just read to you this amazing book. You can get it by calling that number on the record, and you can now join us on Boon TV. I'll put the link to our new channel in the description below. You guys can email us if you have queries or situations that you wish to remedy, and we will do our best by the grace of God. Thank you guys, and have yourself a great day. A shout out to all our people here who write to us on the daily, and we are so happy to hear your testimony, you guys, of all of you guys who've been winning. Alright, have yourselves a great day, and thank you to the international authorities for all your help along the way. Finish up the rest of the cases for us and remedy all the stuff, and thank you for all you've done for us so far. Have a great day.